Welcome back, everyone. I've got a topic here that I really want to make you aware of. Last spring, New York legislature, in passing the budget bill, it was either an amendment or was included in the bill. Two things regarding criminal justice reform. And joining me today is Jason Carusone, who is the DA for Warren County. So first, welcome, Jason.
Hi, Jason.
Nice to have you. It's
Yes,
good to
thanks for
see you
having
as
me.
always.
Yeah, it's nice seeing you.
And the more I found out about this, the more I talked to Jason about it and some of the supervisors in Warren County, the more I realized that we should make you aware of some of the elements in this criminal justice reform, good and bad, and how it affects us and what we might be able to do to try to help people in law enforcement do their job. I'm right so far, right? Last spring, the New York legislature, in passing the budget bill, had this criminal reform included inside it. And it covered essentially two areas.
Correct.
Bail and discovery.
That's right.
Now, what we're going to do is we're going to break this interview into two parts. We're going to talk about bail right now, and then we're going to come back at another time and talk about discovery. So let's get into bail. In our own community here, it was heightened recently because there was a terrible tragedy at Exit 25. And I remember being at a supervisor meeting and they were talking about it and they were mentioning some of these reforms, quote unquote,
Right.
regarding bail. Help us understand where we were and beginning January 2020, where we're headed.
Sure. So right now, it's December of 2019, so we're under the CPL 240. That's our current set of rules. Those rules are going to be completely eliminated, and we're going to be under a new set of rules, CPL 245, starting January 1st, so it's only a few weeks away. Currently, a judge in any criminal matter can consider setting bail or some other form of financial bond, something along those lines, to assure that a defendant who's accused of a crime comes back to court. As you know, we have crimes that range from petty larceny all the way to different homicides, murder, etc. The judge can consider right now all kinds of factors to make a decision on whether or not to have some bail enforced. That's about to change, and the judge's discretion is going to be severely altered and reduced come 2020. And I think maybe by way of example might be worthwhile.
Sure.
And I don't want to speak about specific open cases, but I can talk to you generically. I've been at the DA's office for 20 years and doing criminal laws for, I guess, 23 years. 23 years. So I've seen a lot in the county, and we get, as I said, all kinds of crimes. Something that's very common here is people will come actually from other areas to our outlets, which are just down the street from where we are, and they'll steal. That's something that happens. It's not that uncommon. Currently, a court can consider a lot of factors in deciding, do I need bail to make sure this person comes back to court and appears whenever they're required? So if someone were to go to the outlets and steal, say, $900 worth of merchandise, and they got caught, that's a petty larceny. And oftentimes you wouldn't see bail set on a petty larceny. However, bail could be set. For example, let's say that person's from New Jersey, so they're not from New York State. They have a long criminal history. They have a history of not appearing for court, maybe a history of bail jumping. And now the judge could look at that and say, oh, I think we need to set some bail. I want to make sure this person comes back and deals with their case. Under the new law in 2020, a judge won't be able to set bail in cases like that. The only time at first blush, so an arraignment on a case, that a court can set bail next year is going to be for violent felony offenses and other what they call qualifying offenses. And that's a limited number of cases. I gave you the example of petty larceny, but I've also mentioned homicides. We do have homicide cases. I can look back in my time here. One of a common type of case we see is vehicular homicide related to
drinking or something. Right.
drug and alcohol
Yeah,
consumption,
sure. Right.
where a person's killed, or you can have vehicular assault where someone's seriously injured.
Mm-hmm.
Under New York state law, that is not a violent crime, and it is not a crime next year that will be eligible for bail. For example, if someone was driving drunk and struck and killed a family of 4, they could be charged with, and they were charged with manslaughter in the second degree, let's say. Next year, a few weeks away from now, a judge will not be permitted to set bail on that individual. And some of the factors normally you would expect the judge to consider, the judge won't be able to consider. So for example, let's say the person who struck and killed that family was from another country. They were just visiting, because we have a place a lot of people visit. the judge still can't set bail. Let's say that they previously struck and killed a person in another jurisdiction and served their sentence and they're out. That is not to be factored in under these new laws. So the judge's discretion has been pulled away, and people committing what I don't consider small level crimes aren't going to be required to post bail on those cases. Judges can say, well, I'm ordering that you don't leave the jurisdiction. They can put other restrictions on, but they can't set monetary restrictions on non-qualifying offenses. Another one that people have really come to me and said, this can't be true. I mean, I've heard people say, this can't be true. And the example is burglary in the second degree. Someone breaks into a dwelling, so where someone lives, into a home, and let's say they're caught in the home. Let's say they're in the bedroom and they're looking at your spouse. And your spouse wakes up and screams, and the police are called, and the person is arrested on scene. That's a violent crime in New York State. This new law has carved an exception out for that crime and said judges cannot set bail on burglary second dwelling anymore. So even if that person's from previously convicted rapist, it doesn't change the analysis. If they're from another country or another state, it doesn't change the analysis. Next year, our judges cannot set bail on that case. And there's a number of examples that fall into that sort of scenario. And I think the public that I've talked to, people that I've spoken to, they were under the impression, well, this is just low-level crimes. This is going to be like that small incident, someone stole something from Walmart, and they were kind of shocked to hear, no, this includes things that many people consider, and I certainly consider, really serious crimes. Burglary, robbery, aided by another, all the manslaughters, the vehicular homicides, criminally negligent homicide. The list is kind of astounding. Virtually every drug crime in New York State, bail can't be set. So if someone's caught, and we get these cases all the time, out of state or down in the city, they're passing through. They don't even plan to be in Warren County. They're stopped on their way to Vermont, and they've got a large amount of opiates, fentanyl, heroin. They will be released in 2020 by law. The judge won't have a choice. I won't be able to argue for bail. It's not possible if this law goes forward as it's scheduled to in a few weeks.
You know, I want to, there's a question I want to ask you about what we can do. However, I think this question just has to be asked. You would assume that any kind of criminal justice reform would be maybe to try to fight what we all hear, which is that in this country, the incarceration rates are so high. So maybe it's an effort to try to work on that. But I can't, I'm telling you, I'm sitting here and I'm listening to you tell me these things, and I think to myself, one of the major reasons for bail is an incentive, a monetary incentive for someone to actually come back in court. What incentive does somebody have? And I think you were telling me before that they have contact information or something like that.
Oh, right. So,
You know, I mean, like, am I the only one that just thinks, oh, I'll get a phone call and I'm going to go across the state line because I committed, in my impression, a violent crime to stand trial? I don't think so.
well, I mean, these are obvious concerns that we have. Are we going to get a 100% return rate? In other words, when someone from another state is accused of a high-level crime, I mean, you could be in possession of A-level felony drugs, and that's a Class A felony that can have a sentence of up to, depending on your record, up to 25 years. And you're going to be released. So are you going to come back? That's going to be the question. If you don't come back, the law says that the counties pay for all extraditions. So if you are located elsewhere, that financial burden falls on the county. And so there's going to be hard decisions on who do you go and get.
Sure, of course.
If they're found. The other thing you were mentioning was the contact. So the new law says that defendants, people accused, they give their contact information of their choosing. It can be a text message. It can be, I think, an email, phone number, mail, regular mail. And the court must notify them and remind them of all court appearances. Every time it's adjourned, they get a new reminder. If they don't appear and I ask for a warrant, unless it's found to be willful after a hearing, the court can't issue a warrant. They have to give 48 hours and then do another reminder through those methods. So that's new. Everything really is new. It's a really complete overhaul of our criminal justice system. And that overhaul was put into effect in the spring and is expected to be up and running January 1st.
Well, I want everybody to be aware that, we can get our voices heard. Interestingly enough, right here in Warren County, our supervisors sent a resolution to the state just saying we need more time to really analyze what, assuming that what the motive is here is to really just try to work on criminal justice reform, to say we better slow this process down, we better delay it. There's a second part to this, by the way. We all understand bail, right? But I think very few of us understand discovery. And we're going to stop now. We're out of time for this, but I'm going to invite Jason back for part 2 on what the discovery process currently is, and under this reform, what it will become. In the meantime, you can go to our website, looktvonline.com.